Imagine waking up tomorrow to find that your favorite news site is suddenly locked behind an even higher paywall, or worse, stripped of its unique voice by artificial intelligence trained on its very own articles. This might sound dramatic, but we are now at the tipping point of a global clash that could reshape how we access information, who profits from content, and what privacy truly means in the digital age. In early 2025, a storm broke out in the world of AI and journalism. The New York Times, one of the oldest and most trusted news organizations, launched a multi-billion-dollar legal assault against OpenAI, the creator of ChatGPT. At the heart of the conflict, the use of news articles, without consent or compensation, to train large language models. For years, AI companies have fed their algorithms with oceans of data scraped from the internet. News stories, blog posts, research papers, almost anything published publicly has been fair game. OpenAI argues that this practice is legal under the principle of fair use, claiming their use of content transforms it in ways that add new value to the world. As OpenAI spokesperson Jason Dutram puts it, "We build our AI models using publicly available data in a manner grounded in fair use and supportive of innovation." But the New York Times disagrees, strongly. In August 2023, they updated their terms and conditions, explicitly banning the use of their material for AI training. Their lawyers argue that OpenAI and tech giant Microsoft are profiting wildly from stealing the original content of newspapers across the country. Attorney Stephen Lieberman, representing the Times, summed it up bluntly. "We appreciate the opportunity to present a jury with the facts about how OpenAI and Microsoft are profiting wildly from stealing the original content of newspapers." The legal battle ramped up quickly. By March 2025, a U.S. district judge allowed key copyright infringement claims from the Times to proceed. Soon after, multiple copyright lawsuits against OpenAI and Microsoft were consolidated in Manhattan federal court. The stakes? The Times is demanding billions of dollars in damages and even the destruction of AI models and training data that include its articles. But this legal drama is about more than just corporate profits. It's a clash of values, the right of creators to control and monetize their work, versus the promise of AI to democratize knowledge and power new opportunities. At its core, this fight is also about privacy. As part of the ongoing suit, the Times convinced the court to order OpenAI to keep all ChatGPT user content indefinitely, hoping to hunt for evidence. Suddenly, the privacy of over 400 million weekly users, everyone who has typed a question or shared a thought with ChatGPT, is on the line. Brad Lightcap, OpenAI's COO, warns, "This fundamentally conflicts with the privacy commitments we have made to our users. It abandons long-standing privacy norms and weakens privacy protections." OpenAI has appealed the court's order, arguing that indefinite data retention is an overreach and could set a dangerous precedent. Only a small, highly monitored legal team will have access to this data for now. But the anxiety is real. What if private conversations, business strategies, or personal musings become part of a legal discovery free-for-all? Meanwhile, the court is delving into the nitty-gritty of AI technology itself. Can ChatGPT's summaries truly replace reading the original New York Times articles? If so, is that a form of market substitution that harms journalism's business model? Judge Sidney Stein underscored the seriousness, saying the Times' numerous and widely publicized examples of ChatGPT producing material from its articles justified allowing the claims to continue. On one side, journalists warn that AI-generated content could undermine the integrity and survival of quality news. On the other, AI advocates insist that using public data accelerates innovation and benefits society. Aswin Prabhakar from the Center for Data Innovation argues, "The New York Times lawsuit mischaracterizes the nuanced dynamics of AI development and the principles of fair use." So we are left with a stark question. If AI can learn from anything written online, who really owns the future of content, and at what cost to our privacy and our free flow of information? With billions of dollars at stake and the eyes of the entire tech and media world watching, what happens next could alter the rules for everyone. What if the court sides with the Times and forces OpenAI to destroy not just data, but the very models powering the next generation of AI? Or will the promise of innovation and open knowledge prevail? The answer may change the fabric of the internet itself and your digital life forever. Let's look ahead. The consequences of this legal clash will ripple far beyond just the New York Times and OpenAI. If the court sides with the times, we could see a future where every AI developer is forced to obtain licenses for all training data. That could mean a surge in costs, stricter access to information, and potentially the end of the open data era that has fueled so much recent innovation. Imagine a world where chatbots, translation tools, and research assistants are only as good as the licenses their creators can afford. For smaller startups and researchers, this could be a devastating blow, stifling creativity and reducing competition. But the other side of the coin is equally dramatic. If the courts favor OpenAI, we may enter an era where news organizations and creators struggle to maintain their financial viability, with AI models generating summaries and answers that undercut the need for original subscriptions. As one attorney for The Times put it, we appreciate the opportunity to present a jury with the facts about how OpenAI and Microsoft are profiting wildly from stealing the original content of newspapers across the country. The risk? High-quality journalism might shrink, and the internet could become a sea of AI-generated echoes of real reporting. There are also privacy stakes at play. OpenAI's chief operating officer Brad Lightcap has warned, "This fundamentally conflicts with the privacy commitments we have made to our users. It abandons long-standing privacy norms and weakens privacy protections." With over 400 million weekly users affected by the data retention order, a lot more than legal precedent is on the line. Our own digital privacy hangs in the balance. So, what does this mean for you? First, it's a wake-up call about the trade-offs between innovation, privacy, and intellectual property. If you use AI tools for work, learning, or creativity, stay informed about their data practices. The rules could change at any moment, affecting what you can create, how your data is handled, and even how much these tools cost. As a user, always check if your platform offers data retention controls or privacy options, especially if you're sharing sensitive information. If you're a creator, this lawsuit is a signal to rethink how you protect your content. Watermarks, copyright notices, and clear terms of use are now more critical than ever. Content deals between media companies and tech firms may soon become standard, giving creators more leverage and new income streams, but also introducing new legal hurdles. The bigger lesson? The intersection of law and technology is now everyone's business. As these battles play out in courtrooms and legislatures, they shape the digital tools we all rely on every day. Staying informed is your best defense and your best advantage. In the end, will the legal system choose to protect creators' rights over innovation and privacy, or find a new balance? The answer, for now, is that the future is unwritten. What's certain is that this lawsuit has already forced a global conversation about what fairness, ownership, and privacy really mean in an AI-driven world. And here's a secret most people don't know. Many AI models, not just ChatGPT, have been trained on massive internet archives, including public posts, forums, and even user comments, sometimes without explicit consent. This legal case could be just the tip of the iceberg, with ripple effects for countless online communities and platforms. What do you think? Should AI innovation come at the cost of privacy or creative ownership, or is there a way to have both? Let us know in the comments. If you found this story eye-opening, subscribe for more deep dives into the battles shaping our digital future. Until